Good evening. This is John Milburn for LAWS11057 Introduction to Law. This is week 6. We're dealing this week with communication as a lawyer in our reading, but week 5 material dealing with research is a huge area and it often encroaches into week 6. So we're going to start with some material in relation to legal research. Having said that, I do expect that everyone in the unit has completed their reading in relation to legal research. So that is the chapter in the text, and I've also looked at each of the recorded videos in relation to legal research. If you haven't done that already, please do so now. It's critically important that you are able to find the law, identify where material is sourced and recorded in the online materials that we have, both free and through the paid service CQU online library. I take it also that everyone has been to the library and has undertaken some research around what's available on the online resources. Again, if you haven't, please do so immediately. Let's start our discussion tonight with OSTLE. Now, I assume that everyone is familiar with OSTLE, you know what it's all about, and you're able to complete some basic functions. So I'm going to ask those that are participating live to compete in a little exercise. If you've seen the legal research videos, you've got a big advantage in relation to this exercise. Those that are watching this as a recorded session, I'm going to ask you to complete the same exercise, which means pausing the recording and undertaking the research. So here's the test that I have for you. Are we ready on our buzzers? We're ready on our fingers. You'll need to be in OSTLE. I'm going to ask you to find the second citation in Note Up to Section 15AA of the Acts Interpretation Act 1901 Commonwealth. When you've got the answer, call it out or put it in the chat facility. My apologies. Ronnie just pipped Abby, and Tuna, I think you were very close. So well done. If you're watching this as a recorded session, the answer was Getty's Purpose and Context in Statutory Interpretation. So that's good. Next exercise, ready on your buzzers. What would be the Boolean connector that you might use if you're trying to find the first term, whether the first term is within the number of words of a second term? What's the Boolean connector used? Have I stumped everyone? W/N would be the appropriate answer. So the words within a certain number. And an example would be, if you're looking for the term or the word court, C-O-U-R-T, and the word jurisdiction, and you want to find those two words within 5 words of each other, the Boolean connector that you'd use in OSTLE is court W/5 jurisdiction. Court within 5 words of jurisdiction. Do you get the idea? So as part of a toolkit that you might develop, I think you should have a list of connectors, Boolean connectors, and at least have them for the major search engines that you might likely use, so that you've got a quick ready reckoner if you're looking to undertake some legal research. I think last week I may have set some homework. Did I ask you about Section 754 of the Police Powers and Responsibilities Act? Can anyone give me 2 cases that relate to that section? You can just put in the name of one of the parties if you like. Section 754, Police Powers and Responsibilities Act, Queensland. 2 cases, just the names of the parties, or a name of one party will do. Using the chat facility or unmute your microphone. If you're watching this as a recorded session, don't just be listening. You're working hard now, trying to beat those that are watching live. 754 PPRA, 2 cases, please. Ronnie's come in first. Zabrinsky, Ham and Toll. Very good. Full citation as well. Quick typing. Or copy and paste. All right. Others that I've copy and paste. Always good. Any others? Can anyone see any other cases? All right. But the idea is that you need to do that, move fairly quickly to do it. All right. Next exercise, can people find for me the Australian consumer law in Austerley? And tell me how you found it. Don't Google it. Find it in Austerley. There's a few different ways to do it. The Australian consumer law. Ronnie's done a cut and paste. Well done. You can tell us later how you found that citation. Ah, very good. That was what I was hoping for. Ronnie used the advanced search. So if you're watching this as a recorded session and you're not using the advanced search, firstly, you've got to find out where it is. Secondly, start to work out how to use it. The Australian consumer law. If you're looking manually, I'll give you a hint. It's Schedule 2. Timothy's got an answer. Well done, Timothy. Schedule 2 to the Competition and Consumer Act 2010, Commonwealth. Tuna's got there as well. All right, so well done. So these are the sorts of things that need to become second nature. Work on speed, undertake some exercises, see how you can cope. If you read some textbook material and you see a section, ask yourself, I wonder if there are any cases or articles relating to that, and see if you can find them. You can understand that by referring to material that you have sourced outside of the textbook, you're likely to have a more comprehensive and better answer, and therefore achieve better results. Now, does anyone have any questions? All good? If you're struggling, please ask through Q&A, and not only I, but your colleagues will be very happy to help you. So this is a collaborative effort, and we want everyone to work through it. So well done, Ronnie, and very good work from others who are very close. The Federal Register of Legislation is also known as the Legislation Register for Commonwealth legislation, but not just legislation. It has Gazette information, bills, explanatory memorandum, etc. So you need to be well aware of that website and work your way around it. If you're struggling, if you need more detail, look at the pre-recorded sessions on legal research. So we won't be going through all of that tonight. You need to quickly find bills and explanatory notes or explanatory memorandum. All right, ready for another quick exercise? Queensland legislation, victims of crime assistance and other legislation amendment. Can you tell me, this is 2000, or is it 16 or 17? Can you tell me the date of the third reading? Victims of Crime Assistance and Other Legislation Amendment Act. Now this is the amendment from 2016 or 2017, I'm sorry. What was the date of the third reading? No takers yet? You're all probably very close. Or Tanya, well done. 28 March 2017. Excellent work. Again, if you're watching this as a recorded session, this is the sort of speed you need to achieve. Okay, well done, everyone. Has anyone looked at LAWLEX? LAWLEX? It's also a good way to search, has simple and advanced search functions. So if you don't know, for example, that the Succession Act is the main piece of legislation dealing with wills and administration, the sort of search function that you can undertake through LAWLEX will assist you. So go to LAWLEX, don't worry about it now, but browse legislation, untick all but Queensland, enter the category wills and estates, and then browse, and it will come up for you. It will provide for you the main acts and the main pieces of legislation relevant to wills and estates. So that's a very handy way of searching. If you don't remember the precise name of the act that you're searching for, you know that there's some act that deals with wills and estates, but you wouldn't necessarily know it's the Succession Act. Does that make sense? So LAWLEX is useful as well. The Queensland Reports website I mentioned last week provides for authorised reports. You need to have a good idea of what's authorised, what's not. I imagine that's the sort of thing you'd have in a toolkit. Now, Jade. Do I take it that everyone is now subscribing to Jade and at least receiving material on a weekly basis, updates in their area of interest? Yes, yes, good. We're getting a lot of yeses. Again, if you're watching this as a recorded session, go to Jade Barnett, have a look at the 1-minute video that gives an idea of what it's all about. Jade, by the way, is an acronym, Judgments and Decisions Enhanced, and boy, is it enhanced. Jade is a terrific service. So one of the things, and I think I mentioned this last week, one of the things I really like about Jade is that when you go into a case, and it's free, when you go into a case, it will give you an idea of how often certain parts of that case have been cited or referred to elsewhere. And that then gives you a good idea of where to look. So if you're reading the authorised but unedited version of a judgment, or there's no assistance in it, it's very hard to identify necessarily what's the important part. Go into Jade and you can just look at where the action was, so to speak, and you think, well, that's the important part. Timothy's giving it a plug, was very helpful with his assignment. Excellent. So I think I use Jade from a practical perspective, and it's very useful. The worked example that I refer to in the recorded videos is something to do with negligence, balcony, and fall. If you use basic or even advanced searches with those three words with simple Boolean connectors of and, you'll have a great number of results. But whatever search engine you use, you need to start using the advanced filters and selecting the various filters to bring it down to a manageable size. So in Jade, if you don't already know about Jade's case trace, you need to find that and use it. So in the top right-hand corner of the Jade website, you'll see case trace. If you're not sure how to use that, or OSTLE, or the Legislation Register, or any of these websites that I'm referring to, all of them have excellent online resources. In the case of Jade, a short video. Otherwise, worked examples. You've got to understand these and be able to use them, and use them quickly. Then, of course, there's a lot of personal preference, because some people say, I use Jade, others who use LAWS11057, and you'll develop what you prefer. So, and the ones that I've mentioned so far are just the free ones. You also need to know Lexis Advanced Pacific. Great resources there. Does anyone know Lexis Advanced Pacific? Have we all been and had a look? Can anyone tell me what their favourite platform within Lexis Advanced Pacific might be? I'm testing you here, I know. So people are looking at it, but what's your favourite? Any platforms that come to mind? Well, I'll give you an idea of what's in there. Queensland Reports, Casebase, Hallsbury's. Gareth got in just as I was about to say it. Well done, Gareth. Hallsbury's is a great way to look. If you're really stuck for an assignment, you're looking for ideas, have a look at Hallsbury's. You'll find Hallsbury's in Lexis Advanced Pacific. But there's a whole lot more in there that's really valuable. Australian Encyclopedia of Legal Dictionary, Australian Current Law, Carter's Criminal Law, Cross on Evidence. So a lot of excellent material. So go through some worked examples and maybe use the same worked example that I've used in the legal videos when you're doing your own research, just to get an idea. So because it's a year old, those legal videos, the numbers that I quote in terms of the number of entries will change. So everything changes very quickly. Other than that, you need to know Westlaw. Westlaw includes some valuable resources. Can anyone tell me one of their favourite platforms within the Westlaw Law Resources platform overall? Westlaw, any favourites that come to mind? I really am testing you tonight, I know that. Pushing you hard. Casebase, yes. Well, what do we call Casebase? In Westlaw, it's First Point. The other one, which is similar to Hallsbury's, is excellent, the Laws of Australia. So Westlaw has some brilliant material. First Point is an online law research tool. It gives you information about citations. So it's one of the series of citators that you need to understand and use. Otherwise, CCH is very important. Look at CCH and Hein Online if you're really looking for advanced subscription material. Other than that, please work your way through the legal research material, and if you have any problems, please ask for assistance. All right, that's all I propose to talk about in relation to legal research. I know that's a brief overview, but much of it requires you to do private study and go on some exploration. Find something that works for you. You will find material that I do not mention in the 4 videos about legal research. I'm sure you will, and you'll find things that work for you well. So, and if you find something that's good, please share it with others and use it as something that we can all gain from. Now, are there any questions, comments, any tips about legal research, anything that you wish to ask or share? All good? All right. Communication, just a quick note about Turnitin. Now, is anyone scared of Turnitin? You've seen it? When you submit your assessment work, you'll have a Turnitin score. This is a program that's used by the university, by many universities, and it's primarily, I've got to be honest, to guard against plagiarism. So you'll understand that when you submit your work, Turnitin is a very powerful program that has the ability to assess your work against the work submitted by other students or other resources online generally, articles, cases, legislation, whatever it might be. So it's very important that you understand Turnitin and be aware of the power that it has to detect issues to do with plagiarism. There's no individual score that I can give to you to say, well, that's safe. I can indicate that from my end, once the scores get to certain levels, the colour changes so that I'm on guard to look out for information. But you can have a Turnitin score that is very high and yet not breach any plagiarism rules, or you can have a Turnitin score that's quite low and yet be guilty of plagiarism. Now, can anyone tell me why that might be the case? What logical reason would I have for saying that? Timothy's got, yep, referencing. That's one of them. Referencing. If you reference your material, Turnitin will still acknowledge that you sourced it elsewhere, but if you've referenced it appropriately, there's not a problem. So that might be why you have a relatively high Turnitin score and not be a problem because you've referenced it. Conversely, of course, you might have a low score, you haven't referenced it, it's quite critical and relatively unique, and therefore you're guilty of plagiarism by not having referred to it. I know sometimes it may be possible for you to inadvertently breach the rules. I guess the late George Harrison got pinged for the song My Sweet Lord, where he said, I didn't realise that I had collected this melody and these notes and this particular collection of chords from a different song. So sometimes that will happen. But generally speaking, you need to be on guard for this and ensure that what you produce is your own work or you acknowledge the work of others. Sorry, we drill this into you in first year because we don't want you to get to the end of third year and find that you've been breaching these plagiarism rules. So I need to stress that the Turnitin score alone is relevant, but it's far from being the only relevant factor. You might cut and paste an entire piece of legislation in a short form assessment, have a high percentage score, but still be fine. And conversely, there might be an issue. All right, now let's move on to written communication. Quality writing is all about using language in a way that conveys information to an audience. I'm not really interested in reading something that might be very grammatical, what's the right, what I'm really trying to say, this is communication issue week, I'm really trying to say that you should tailor your communication to the recipient rather than necessarily intentionally go about showing how impressive you can write. Does that make sense? Now, generally, when you're reading something, you would like to understand it with the minimum of effort. I think that's generally the proposition. I'm going to put this to you, that there's a difference between the sort of writing that people might use in a novel compared to the sort of writing that you might use in an opinion, a legal opinion, or a legal advice or a submission to a court. Yes, Timothy says, Irving Younger's 10 Commandments video. If you haven't seen it, just go and look that up. It's great. I'm not sure if I put it on Moodle or not. So having information that is conveyed accurately and efficiently is the important thing. I do want it to be grammatically correct, and as some guides, using short sentences in the active voice is a way to go. Have a look at the threshold learning outcomes, and in particular outcome number 5, and you'll see what I mean. So that's in the context of using short sentences. Find it in your textbook. Have a look at the list that relates to threshold learning outcome number 5, and you tend to gloss over it, I think. So then look at the think box in the textbook as well, and there's a few things that you want to consider. The link is on Moodle for Irving Younger's, I'm told. So what we want to do is avoid legalese. We want to avoid jargonistic language, and we want to avoid long words used in incomprehensible sentences. In other words, what we don't want is language, as was the case used by lawyers, that might be regarded as pompous or jargonistic or arrogant or using archaic language. Do you understand what I'm getting at with all that? So simplicity and easy to understand phrases and questions is the approach that we'd like you to adopt. And it's safer. If you use short sentences, you're less likely to fall into error or cause confusion in the mind of the reader or ambiguity. Rachel has a great word for it, succinct. Exactly. So that's what we're looking for. So when you think of lawyers, you probably thought of them using long words or big words, long sentences, pompous language, and almost an intention to confuse. I've got to say, it was like that when I first started. So instead of having a long sentence and phrase, try to communicate in a single sentence or phrase where you can. So remember that when we're talking about communication, it's one of the 6 key threshold learning outcomes. Remember back in week 1, we talked about what we're trying to achieve in this law degree: knowledge, ethics and professional responsibility, thinking skills, research skills, communication and collaboration, and self-management. So what we're talking about here is number 5, communication and self-management. And back in the 70s when I started, all we really were looking for was, I think, knowledge. We really didn't teach these other 5 critical skills that lawyers need. Rachel's raised a really good point, and that is it's important to write in a way that caters for meeting word count limits. And just on that point, whilst you can get away with exceeding the word limit a bit with assessments that you provide to me, if you exceed the word limit, I'm then going to look more critically at your language to identify whether you have used your words efficiently. And if you haven't, you will then be penalised. So you're not penalised directly for exceeding the word limit, but you run the risk of being penalised for using words inefficiently. Does that make sense? Now, other unit coordinators will make it clear that the word limits are strict, in which case don't go beyond. Some unit coordinators adopt a practice of not reading any words past the word limit, for example. So you need to ensure that either way, you're writing in an efficient manner. So when it comes to legal problems and research skills, what you're trying to do is to find the law and then explain the law in a simple and effective manner. Let's just talk about the second assessment for a while. Can I ask this generally? Has anyone started their second assessment? And the reason I'm raising this is that I think it's directly relevant to the issue of communication, and it follows on from legal research. Have we all started our second assessment? Yes, good. If you haven't, if you're watching this as a recorded session, please do so. All right, so pondering, that's fair enough. So what are the key elements for this? In the task overview, we say, during term, we've asked you to think, speak, and act like a lawyer. What that means is that you need to understand the process of solving legal problems. How do you go about solving legal problems? You need to identify the material parts, then you need to find the law. So we should now have a good idea of how to find the law. Then the question is, how do we apply it? And importantly, how do we communicate it? So in the second assessment, the legal toolkit, or the problem-solving toolkit, you have this opportunity to showcase your skills in all of those areas. In terms of communication, what I'm looking for is your ability to communicate in an effective manner and to show that you have understood where the material that you write about is sourced. It's important that you do provide a pathway to having a problem-solving technique. So when you, and I know we're talking about communication, but I'm digressing into the second assessment because I think it's really important before we go into the break that you really have this under control. So when you're doing, when you're preparing your toolkit, you need to be able to refer to the Australian Guide to Legal Citations, and you need to apply it. I assume everyone knows now how to find a quick guide to the AGLC, and everyone knows how to use referencing from a technical perspective. If you don't, please stop the recording, try and find out, or ask some questions, but it's really simple in the Word program. You need to have some idea of some examples that you might use. So as part of the toolkit, you need to talk about some things like the doctrine of precedent, or distinguishing a case, or the rule of law, or even noting up. In terms of reflecting on professional development, we need to see your skills in problem solving is primarily what we're looking to do. And when you're writing generally, and when you're preparing your toolkit, think about this also, that the way in which you communicate through your tone, the voice, the pace, is all very important. So to some degree, in oral communication, you're using some acting skills. You certainly do in court, and I think you need to with clients and colleagues also. So just as an exercise, and this is maybe something that you'd incorporate in your toolkit, or maybe it's something you'd just like to reflect upon, in terms of your oral communication, I'm just going to ask you, not now, but as an exercise during the week, to stand at your desk and think for a moment that you are addressing a court, a judge, for example, and think about the physical space that you have around you and ask yourself, how much physical space do I need? In other words, what is your posture? Would you stand up very straight? Would you be more relaxed in your stance? Would you slouch? Would you use any arm movements? Or would you remain perfectly still while you address the court? And then you might think about that in the context of, say, addressing a jury, or in the context of addressing someone in a mediation session. Think about the way in which you make your first statement. Timothy says, and this is a good point, I can't talk without moving my hands. Therefore, would you seek to restrain that natural movement, or would you use it as part of your armoury? My personal view, use it. Yes, we're getting a lot of votes for use it. My personal view is that when you're speaking with a judge or addressing a jury even, you should use the space around you. Unlike the American system, I wouldn't move too far off I wouldn't move your feet too much. You might move a few inches only, or maybe up to 6 inches, but you're certainly not walking around. But I would say that you've got at least half a metre either side of you, which is your space. That's your domain, and you can use that. Probably not so much above your head, although to make a point, you might use that. But that area to the side of you and in front of you for at least half a metre, I think, is space that you should use. And in addition to that, I don't think you should stand rigidly straight. I think that you should adopt a comfortable style. All right, so using an open hand method is something that Timothy likes, and I think that's a good idea. So just think about that and actually go through that exercise. Then picture yourself having to make the first sentence to a court, for example, and ask yourself, what would I do? Would I take a deep breath? Would I maintain eye contact? Would I be looking at the notes that I've prepared? What type of notes would I prepare? Would I use some sort of platform, or would I hold the notes in front of me? Often when I'm in court, I actually use my computer, and I'll work off the computer. So if I'm cross-examining a witness, I may have some written questions, but quite often I'm using my computer. Would you do that? Would you have the confidence to use a computer or a tablet in that context? Which means, do you know the technical side well enough so that it won't let you down? I think the first sentence is critical in anything that you do, so make sure you practice that. Have an excellent opening sentence. Speak slowly, speak fluently. And here's a mindset idea for you, that when you're addressing a judge, even on a submission, for example, let's say on a submission on sentence, there's nothing wrong with adopting a mindset to yourself to say, you are a storyteller. And the court is interested in what you have to say. And therefore, you can assume this, and this is meant to be something to inspire you to have some confidence in your oral communication. The court wants you to do well. The court wants you to do well. So be confident and know that that is the case. Why does the court want you to do well? Well, the court wants to receive good information from you so it can make the best decision. It wants to be interested in what you have to say, and the court is keen for you to explain yourself in a way that works well and is effective. Sometimes you need to use your breathing to good effect. So you may need to pause. You may need to breathe. Here's an exercise. If you just write this down for me and use it as a contrast. The phrase is this: and then his mother died and he went off the rails. Did you get that phrase? Now, and then his mother died and he went off the rails. I'm going to ask you just to identify now 2 ways that you can express that sentence or phrase, if you like, and whether you can change the emphasis. I know that's probably a little bit bizarre, but see if you can do that.
John, whilst we're talking about communication, I thought I may add that there is a Toastmasters For
Yes.
those of you who hasn't heard of it, it's a public speaking club, and there's one pretty much in every suburb around Australia. And there's over 15,000 clubs worldwide, and you go each week to meetings and you stand up and you present either a prepared speech or any other topics, small speech topics on the agenda they may have. And I've been going for 5 years, and it's really helped me with my communication and just becoming more confident with myself. And all the things that you've run through, they teach all those skills there. So it's amazing.
Excellent. Well, thank you very much, Ronnie, for that. And look, I think I went once as a guest, and I was really impressed with what the members did. And it struck me as a good way of meeting with people as well. So Emmanuel says, what is this called? Toastmasters. So good recommendation, Ronnie. Thank you for that. All right. Now, can anyone deliver that line in a way that might have maximum benefit? And then his mother died and he went off the rails. Is there only one way to deliver that? Who wants to unmute and give it a go on how to deliver that with maximum impact?
I'll give it a go, John.
Thanks, Ron.
And then his mother died and he went off the rails.
Very good. Excellent. Is there any other way that you could say that? Emmanuel says, I would emphasise off the rails. Tom says, how would you react if your mother died? He went off the rails. And then his mother died and he went off the rails. Yes, so there's different ways of doing it. And sometimes it's a matter of emphasising a certain word or having a pause strategically. And then his mother died and he went off the rails. By just maybe having that pause, you're allowing the recipient to take that in, and then you have the further line that goes with it. Now, you may not need that pause. There are a lot of different ways of doing it. But the point is that when you have a key part of your communication, there's nothing wrong with preparing in advance and even practicing the way in which you wish to deliver that. When it comes to communication, I mentioned the importance of understanding and working with your recipient. Let's talk for a moment about interviewing clients and the communication techniques inherent in that. So, what are some of the important things? Well, the first is that you need to think about the object of your legal communication. And an important part of communication is understanding. But it works both ways. And this is, I think, sometimes overlooked, that the understanding is important for you to understand the client, but also for the client to understand the importance of you knowing what it is that you want them, the importance of the client being aware that you understand what you are to do. And you can even say something like, to be very direct with a client, what do you want and what do you want me to do? So that there's a very clear meeting of the minds there. And it's sometimes overlooked, and it's really quite simple. In order to achieve proper communication with a client and interview a client, an aspect that's very important is active listening. Active listening. You're taking it in, but you're working really hard while you're listening. It might look like you're doing nothing, but you're actually working really hard. In terms of active listening, you need to ensure that you do not jump in too early. We see this as a common mistake. A client goes to say something and you think, oh, I know what this is all about, and you jump in. So just be careful not to jump in too early. Having said that, you can't allow the client to go off on tangents. It's too expensive an exercise to do that. When you're active listening and you're trying to extract information, say what is needed, don't go any more than that, and be very careful and measured in your questioning. Interviewing a client is a little like the process of examination in chief of a witness in a court proceeding, where you're trying to extract the evidence in a measured way, and you're trying to extract the important material evidence so that you can properly come to an answer. So bear in mind that when you're interviewing a client, ultimately it's likely that the client wants you to give some advice. And if you think about that MIRAC idea, you've got to understand the material facts first. So interviewing the client is asking questions designed to extract the material facts so that you can give the proper advice and apply the law appropriately. Gareth says it's important that you know when to stop them. Exactly. So somehow, if you can, over the next couple of weeks, improve your ability to interview clients through asking careful questions after you've actively listened, that's a skill that will help you if you go on to do court work. And you might tell people that you're actually trying to do this as an exercise, or you might just go into this and see how you go. So if someone wants to tell you a story, rather than necessarily, without being rude, without necessarily just listening to the story, see if you can guide the process by carefully asking questions so that the people actually feel that they're getting their message across to you better than they would be if you weren't asking those strategic questions. That's a tough ask, I know, but you may even do that as with someone with their knowledge. Now, when you're interviewing clients face-to-face, there are a few things that you need to consider. You need to be comfortable and you need to make them comfortable. But at the same time, you need to maintain authority, don't you? They're coming to you as the expert, so you need to maintain control. And a big mistake when interviewing clients is to let the clients run the show. You've always got to maintain the authority and you're in control of the process. Part of that means be confident and professional. Exactly. Maintain eye contact. How do you do that whilst at the same time taking notes? Any ideas? How do you maintain eye contact but still record notes, which are very important to do? Friendly and firm, says Tuna. Yep, I agree with that. Right, Timothy says recording device. Yes, maybe. Tape recorder. You've got to be very careful about ethical requirements here, but that's an option. A paralegal next to you. Yes, expensive, but sometimes used. Short, important notes, says Tanya. Yes, I agree with that. Maintain eye contact. Record notes after their statement. Yes, but you may need a good memory, says Megan. Gareth says going back over what they've said to give you time. Yes, that's important as well. I can tell you the one I use. Learn to write or type without looking. Yes, that's actually important if you can do it. What I do is I use voice recognition software, and I have it running so that, and I have my quick on-off situation, so that if the clients are saying something, I might even just through some body language say, "Oh, just stop you there," or just a gentle guiding, or just use those words, "Just stop you there," and then as I'm confirming back to the client, I'm actually typing my notes using my voice. And it might be, or just stop you there. So what you're telling me is that you've been separated now for 9 months. You have an issue in relation to the children. You're concerned about the levels of alcohol consumption of your former partner, things of that nature. And when I've stopped giving that summary, I'll have that typed up on my sheet. From the client's perspective, it's important because I've been able to maintain eye contact the whole time, and I have summarized in a way where the client feels that they've been heard and understood. So that gives them some confidence as well. So clarifying questions do help, Dragon 15. Yeah, I'm using Dragon 14 at the moment, but Dragon 15 has come out recently. So you can reframe or you can summarize. We use a lot of this in ADR. So I teach alternative dispute resolution. And as a mediator, what you're often looking to do is summarize so that people have understood, that they know you've understood what they've said, or you reframe. Reframing is that subtle art of taking the essence of what they've said, detoxifying it, and then repeating it back, but in a less toxic form. And you might do that with clients as well. See, clients have a real habit of wanting to be disparaging in a way that isn't necessarily helpful for you to take notes or to prepare a court action. So, for example, if the complaint is about a partnership dispute, a commercial partnership dispute, and the comment made by the client is, look, we've got to dissolve this partnership because my partner has spent all his time down at the pub, he's always on the radio, he's never actually doing work. You might reframe that by detoxifying it by saying something like, so it's important to you to have a partner that is productive, focused on the task, undertaking certain tasks. What tasks would you have in mind for your partner to do? You know, that sort of thing. So that's what I mean by reframing. So taking notes selectively is something that you might want to do one way or the other if you're not using, say, voice recognition software. You need to confirm your instructions after the event. Normally that's in writing. If you've taken good notes, you're a long way to doing that quickly after the interview. You need to have empathy, and you need to bring clients back when necessary. So, Gareth said he's just able to bought Dragon 13 for less than $75. Wow, that's brilliant. You need to bring clients back because clients won't necessarily give you instructions in the right order or the right way. So again, guiding the process is important. All right. Just before you go on about that, I need some more information about the way in which you established this patent. Tell me more about this aspect, that type of guiding question, bringing the client back on point. All of this is excellent advocacy practice. So, for example, if you're interviewing clients well, you're asking one question at a time, having an answer, building a foundation, establishing certain facts, and then moving on. And that's very much what a prosecutor would do in a criminal trial or what a plaintiff's lawyer would do in a civil trial. Rapport is important as well. Keep the questions short is a general rule. I actually get annoyed when you watch the news or a current affairs program. It strikes me that the way in which journalists, at least on TV, ask questions is fundamentally different to the way in which lawyers ask questions or should ask questions in an interview or in a cross-examination or examination session. And the way in which I could summarise is this. Not so much leading questions, but that's a good point, Tuna. When I watch the news and you have an interviewer, it seems to me that often they will presuppose certain facts that aren't necessarily true or established. They'll ask double-barreled questions and they'll ask long, repetitive questions following a statement. Lawyers don't tend to do that, at least in a courtroom context, and I don't think you should do that with it when you're interviewing clients either. I think what you should attempt to do is build on the process. Now, you've come to see me about a motor vehicle accident. What was the day? Answer, question. What was the time? Where did the accident occur? What were you driving a motor vehicle? Yes. What motor vehicle? who owned that motor vehicle. Can you see how it's one question at a time and you're building? Now, sometimes clients don't like that because they want to get everything out. And in order to build some rapport and make them feel comfortable, you may need to let them run. We do that in mediations a bit too. Let them go, get it out of their system a bit, and then you have to go back, and it's the art of filling in the gaps methodically. So just have a look at the way in which interviewers conduct questioning on TV and ask yourself, would that be an appropriate way to interview for a client where you're trying to extract the relevant information, or would it be the appropriate way to ask questions in a courtroom? Maybe the interviewing process is closer to cross-examination than examination in chief. I'd probably give them that. Also use the active voice rather than the passive voice. When you're interviewing with when you're communicating with clients, or you're asking clients to communicate with you, use the active voice where possible. Can anyone tell me what I mean by the active voice? And can anyone tell me why I'm making this statement? What on earth difference would it make? Earning someone's trust is chipping away. Gareth says active voice, easier to read, yes. And I would suggest easier when it comes to communication as well. So just think about that. I'm trying to think of an example and I won't. Not the past tense. So it's more direct. So for example, client says, you know, my business was robbed, is less helpful than my employee, Jim Smith, robbed my business. Do you understand? You see the difference? So the first is passive. It gives you less information generally than the active voice. Courtroom advocacy, we'll just move on to that briefly, and this is still within the context of oral communication. The important thing is be prepared, be concise. Quite often state your conclusion and work back from there. Don't rush, be confident, and sometimes supplement what you're going to say in your oral submissions with pre-prepared written submissions that you hand up to the judge or the magistrate. And that might do us for tonight, but what I want you to do over the break is to think very carefully about your communication style. Now, we've been talking a lot about written communication, but I'd like you to make a concerted effort to think about your oral communication. As you ask questions, think to yourself, am I asking this in a simple manner? Am I using the active voice? Am I asking single questions rather than double-barreled questions? Am I clear in what I'm seeking? It might change the way in which you converse. And I think lawyers do have a certain style of conversing, but it's not necessarily a bad way. And it may lead you to have more effective questioning techniques if you think about the way in which you go about undertaking the task. All right, thank you for your patience. Are there any questions about the issue of communication? We'll touch on it a little more when we come back from the break. Are there any questions, and can you see how this is important for the second assessment? All good? All right. Well, next week, Christmas Eve, next week is a week of holiday break. So there's no lectures next week at all. The week after that is New Year's Eve. I think it's a bit tough to have a session on New Year's Eve. So what I propose to do is record the session, pre-record the session for week 7, which coincides with New Year's Eve. So we won't see you next week. We won't see you the week after that. The next time we see you will be, I think, the 7th or 8th of January. I'm not sure if I've got the date here precisely. I'll just see if I do. So that will be for week number 8. Will be the 7th of January. That's the next time that we'll meet live for the live session. Okay, all good? Have a good Christmas. Have a safe New Year. And we'll see you live on Monday the 7th of January. All the best. Bye then.